Dear audience, today I would like to discuss uh, divorce or dissolution of Muslim marriage by another party of the marriage, that is by the wife. Uh, as I have already uh, pointed out in my previous lectures, that union of marriage is desired by the matrimonial laws to last for the lifetime of the husband and wife. But when the relation between the spouses has strained to such an extent that continuation of their union has become not only undesirable in the given circumstances, but at the same time it has become impossible uh, for the spouses to cohabit with each other. In this situation, the spouses are allowed to separate from each other by terminating the bond of union of marriage. However, a union of the marriage can be dissolved uh, by the husband, as well as it can be terminated or repudiated sometime under certain circumstances by the wife herself. The termination of the marriage at the instance of Muslim wife uh, by Khula, Tafweed or Mubarat has been recognized from the early period of the Islam, and thereby both the spouses has been placed on equal footing or on the level of equality. Uh, just what I am trying to convey, that under Muslim law, in terms of matrimonial laws, the husband and wife both stand on equal footing, on equal level. As for the constitution of the union of the marriage or formation of the union of the marriage, a consent of both the parties is must, because for the want of the consent of either of them, union of the marriage will not be valid one. In the same way, in case the union of the marriage is not going on well, parties are not pulling on well, they are not living with each other with cordiality or amicability, and separation has become inevitable in the given circumstance, then right to separate by dissolving the marriage is given not only to one spouse, but here also both the spouses has been placed at the equal level. As husband has been given the right to repudiate the marriage by pronouncing the talaq in different forms, in the same way, under the similar circumstances, a Muslim wife is also allowed to repudiate her union of the marriage by different way or by different means, and this is fortified. This right that both the spouses are having the equal opportunity or equal right in the equal circumstance to terminate the bond of the marriage in case it has become inevitable. This rule or principle finds support from the fundamental sources of Muslim law, that is Holy Quran. It is stated in the Holy Quran, chapter 2, verse 228, I quote, "And women have the rights similar to those against them men." This verse of the Holy Quran goes to establish that a right to repudiate the marriage is not only of the husband, but under the similar circumstance, the wife of a union of the marriage has also been given the right to repudiate her marriage. Husband can repudiate the marriage by pronouncing the talaq in different form, by Ahsan, Hasan, and until some time by means of triple divorce. Likewise, wife has also the Muslim wife is also empowered or given the right to release herself from the union of the marriage by means of Khula, by way of Talaq-e-Tafweed, or sometime with their mutual agreement, that is known as Mubarat. However, in either case, that is by means of Khula, the wife can repudiate the marriage. By means of the talaq, wife can pronounce the talaq upon herself, and thereby she can terminate the union of marriage. Likewise, sometime parties with their mutual consent can move a joint application for the termination of the marriage, that is known in Muslim law as Mubarat. Here I would like to discuss Khula, because just I have pointed out that a Muslim wife can repudiate her marriage by means of Khula. This is one of the special right given to a Muslim wife, in the exercise of which she can seek the dissolution of her marriage from the husband if the circumstances so warrant. Therefore, the repudiation of the marriage at the instance of a Muslim wife in lieu of her amount of the dower or compensation is called as Khula. So, what is the Khula? Basically, Khula is a legally recognized means in the exercise of the which a Muslim wife can seek the dissolution of her marriage or can repudiate her marriage by making a proposal to her husband that she does not want to continue in the union and therefore she must be released from the bond of the marriage. When a proposal from the side of the wife at her instance is made to the husband, whereby the husband is urged upon to release the wife in lieu of surrender of the amount of the dower or in lieu of some consideration equivalent to the amount of the dower, then the release of the wife at the instance and request of the wife or proposal of the wife in lieu of the amount of the dower or equivalent compensation given by the husband, by the wife, is called as khula. So, when the husband, after accepting the compensation, monetary consideration from his wife, releases on her own request from the union of the marriage, or otherwise that union of the marriage is repudiated, in lieu of the in lieu of the some compensation or amount, or then such type of the repudiation of the marriage or release of the wife from the bond of the marriage is called as khula. So when the husband repudiates the marital tie relationship at the proposal and desire of the wife, in lieu of compensation paid by her to the husband out of her own property, wealth or economic resources, it is called as khula. Imam Abu Hanifa, the founder of the Hanafi school and a great jurist of his time, who has done commendable work on the Islamic fiqh or Islamic jurisprudence, he has explained the meaning of khula, that is the right of the wife to repudiate the marriage. What is khula according to him? He says, dissolution, according to Imam Abu Hanifa, dissolution of marriage for consideration with the consent of the wife is called as khula. Meaning thereby that when a wife, feeling prejudice of her marriage, moves an application, expresses her desire, oral or in writing, before the husband, and at the same time, along with the proposal, she also makes a point that she desires that her marriage should be repudiated by the husband by pronouncing the divorce upon her, and for that even she is ready to pay the some compensation which may be agreed upon between the parties, or she is ready to relinquish the amount of the dower in favor of the husband. And husband accepting the request or accepting the proposal of the husband, wife agrees and pronounces the divorce upon her, and thereby releases her from the bond of the marriage or from the union of the marriage, then such kind of the release by pronouncing the divorce by husband in lieu of some compensation paid or agreed to be paid by the wife is called as khula, or release from the marriage, contract of the marriage. In famous case, Munshi Bazlur Rahim versus Latiful Nisa case, their lordship of the Privy Council, explaining the meaning of the word khula, observed that, I quote, a divorce by khula is divorce with the consent and at the instance of the wife, in which she gives or agrees to give consideration to the husband for her release from the marriage tie. In another case, that is in Musamma Sakina versus Umar Bakhsh, it was held again that in khula, marriage is dissolved by an agreement between the parties for a consideration paid or to be paid by the wife to the husband. It is also necessary that desire for separation should proceed from the wife, where the desire for separation is mutual, then it is called Mubarat. But in Khula, proposal or desire or request for divorce in fact is moved by the wife herself out of her own will or desire, and proposal normally is moved when the wife is not feeling comfortable in the companionship of her husband for whatever reasons. A reason is not necessary to explain. What is necessary to explain? That she is not willing to continue in the marriage, feeling uncomfortable due to the attending facts and circumstances, and if such desires proceed along with willingness to pay something in lieu of release, then a release by the husband will be made, and this release of the wife from the union of the marriage will be called as Khula. So from these two cases it is crystal clear that in case of the Khula, normally the wife moves an application, a request or proposal, or there may be the expression of desire to free her from the contact of the marriage, and for that she is ready. She also expresses the willingness that she is ready to pay even some compensation that may be agreed upon with their mutual agreement, and if in this way the separation between the parties takes by repudiating the marriage, then such type of the separation under the Muslim law is called as Khula, and Khula is an exclusive right given by the Sharia law to a wife of a valid marriage. And as husband can exercise the right of the talaq on the grounds and circumstances, on the similar ground and in the similar circumstance, a Muslim wife can also invoke the right of the Khula and can seek the dissolution of her marriage. The only difference between Khula and Talaq is that Talaq is pronounced by the husband himself upon his wife, and thereby marriage is dissolved. And on the dissolution of the marriage by the husband, wife or divorcee immediately becomes entitled to the payment of entire unpaid amount of the dower. In case of the Khula, in fact, a kind of the proposal expressing the desire that she should be made free from the union of marriage, and the wife makes the request to the husband that even for her release she is also ready to compensate the husband, and compensation may be even sometime the entire amount of the dower which was given by the husband to his wife on the marriage or after the marriage, or compensation may be equivalent to the amount of the dower which was paid by the husband on the marriage or after the marriage. So in divorce, in talaq, divorce is pronounced by the husband. After the divorce, wife is paid the entire amount of the dower by the husband. It becomes due to the wife, and wife becomes entitled to it too. immediately. In Khula, proposal is made to the husband for divorce to the wife, and once the husband agrees to to release the wife, to divorce the wife on her request, on her proposal, then immediately uh, on the pronouncement of the divorce by the husband on the request of the wife either will pay or will agree to pay some compensation to the husband. That compensation may be either equivalent to the dower amount, or it may be the dower amount itself. Whatever dower she has received will be returned to her. The legal basis of the right of the Khula is enunciated in chapter 2, verse 229 of the Holy Quran. This verse says that when the spouses are apprehensive that they cannot live within the limits of Allah set by Allah, then there is no harm in the wife's giving some consideration to the husband to induce him to the divorce her. There is nothing wrong in husband's acceptance of such compensation, nor in the wife's giving it when the spouses are not living in harmony and dissolution has become inevitable due to the disagreement of serious nature. So here are the basis of right of the Khula, because I have just given that wife can secure her release from the husband by paying something, that is. So this rule basically is given in the fundamental source of Muslim law, that is in Holy Quran I have just referred to. So this verse is basically the basis of this legal right, which is known as Khula. However, according to the Holy Quran, the following condition must be fulfilled for the due application of the right of Khula. That condition, number one condition, is that there must be a reasonable apprehension of the husband and wife that they cannot live within the limits set by Allah. Means, I have already told that husband can divorce his wife only, means the ground of the divorce conceived in Islam is the disagreement between the parties. Cause of the disagreement may be anything. Whatever may be the cause, if it has led to the disagreement between the parties, as a result they are not in a position to live together amicably, in harmony, then divorce can be from the side of the husband, divorce can be from the side of the wife. Therefore, wife can move the application or proposal for the Khula provided she also apprehends that in the given circumstance it is impossible, next to impossible. So living, the impossibility of living with the husband due to attending facts and circumstances basically affords the ground to move the application for Khula according to this. So this is one condition, that there must be exist reasonable apprehension that wife cannot live observing the limits set by law with her husband. If this situation exists, wife can move the proposal for her release in the exercise of the right of Khula. The second is that Khula entitles a wife who seeks the separation from husband, and therefore it is she who is to pay the consideration for release from the bond. The second condition for the Khula is that if the wife is moving the application or request for the Khula, then she will have to compensate the husband for the release, because as husband is required to pay the to compensate the wife by paying the amount of the dower. In the same way, if it is wife who is designing separation in the given circumstance, then she is required to pay the husband something equivalent to the divorce or equivalent to the amount of the dower. The right of the Khula also finds support from the traditions. In connection with the validity of the Khula, the case of Jamila and her husband Sabit forms the basis of the right of Khula. This is very famous case. In this case, in brief, I will let the audience know that Sabit was married to Jamila, who was a very beautiful female woman. Uh, in the first night when Jamila met with her husband, she noticed that husband was very ugly. Physical appearance was very ugly. Therefore, in the early morning, she approached to the Holy Prophet and narrated the entire story, particularly his dislikeness to her husband, and requested the Holy Prophet to uh, uh, direct the husband to uh, divorce him or release her from the union of the marriage. After due inquiry from the husband, it is reported in the various books of the traditions that uh, uh, the Holy Prophet directed the husband of the Jamila to release her from the bond of the marriage, whereas the husband was not willing to divorce. He was very much in love with the wife Jamila, but the wife insisted that she may not live in the company of the husband Sabit because of his ugly physical appearance. Only this was the only ground. She explained that he is a very good person, very virtuous person, God-fearing person. There is no defect in his personality except that her physical appearance is not acceptable to her. And therefore, she expressly insisted that since she is having the apprehension to uh, she is having apprehension to uh, cross the limit set by divine law, and therefore she desires that she may be divorced by husband and should be released from the uh, and she made a proposal for Khula. This was the case, perhaps the first case wherein the Holy Prophet ordered the husband to give the divorce and thereby to release the wife by Khula. It may be clarified therefore that the proposal for Khula proceed from the wife, and husband agrees to divorce his wife in lieu of the compensation agreed to be given by her. Where the proposal for Khula is made along with the amount of the compensation agreed paid or agreed to be paid, but husband does not agree to the demand of the Khula, the wife can seek the intervention of the court or the legal authority for her release. On the application of the wife, the court may probe into the cause of disagreement leading to the proposal of the Khula. If the findings of the court proved that wife cannot live with her husband for some genuine reasons, then the court shall order the husband to divorce his wife. This power of the court to direct the husband to release the wife on her proposal, to accept the proposal for Khula in lieu of amount of the dower or amount equivalent to the dower, basically finds the support from the ruling of the Holy Prophet given in the case of Sabit and her wife Jamila. Because just I have pointed out that when Jamila, the wife of Sabit, who was the companion of the Holy Prophet, uh, narrated the entire story of her problem, expressed the desire to be released from the bond of the marriage. She was also ready to pay the compensation, whatever was, even she was ready to pay the compensation. But at the same time, the husband was not willing to divorce his wife because he was deeply in love with his wife. Therefore, he was not willing to divorce his wife, though there was a proposal for Khula from the wife was Jamila. Holy Prophet, after affording the reasonable opportunity of being heard and due inquiry into the complaint and counter argument given by the husband as to why he was not willing to divorce his wife Jamila, Holy Prophet arrived on the conclusion that the argument of the wife seems to be very genuine in context of the union, because of union of the marriage, the pillar of the union of the marriage is mutual love, affection, fidelity, trust, love and compassion for each other. If for whatever reason this element of the love, compassion, fidelity, mutual trust has receded or has gone out of union, then the union will be nothing more than an empty shell, and empty shell should be destroyed. Therefore, the Holy Prophet ordered the Sabit to dissolve the marriage, to divorce, and the divorce was given by the husband. Therefore, if the husband is not willing, the court in the given circumstance can pass the order dissolving the marriage. There are a good number of the cases decided wherein the Khula has been defined, nature of the Khula has been held. Allahabad High Court in Maryam Bibi versus Noor Muhammad held that a suit by Muslim wife to compel her husband to give her divorce under the Khula is not maintainable. It was further held that divorce by Khula is subject to the consent of the husband and is not demandable by wife as a matter of right under Muslim. But this case was not rightly decided. But in Khurshid versus Muhammad Amin, it was held that court has to redress the wrong if it finds that marriage has proved a failure on account of the husband, and accordingly it has to separate the spouses. As a general rule, if the court finds that husband is at fault, it shall order the husband to divorce his wife without any compensation. However, if it is a wife who is found to be at the fault, the court shall dissolve the marriage under the Khula, and wife shall have to pay such compensation as may be fixed by court. A person is considered to be at fault where he or his wife does not follow the laws laid down by the Allah, when he or she transgresses the limits fixed by Sharia. So this is all about Khula, because just the last point I would like to summarize and explain a little bit, that as a general principle of law, wife seeks the Khula in lieu of dower or amount compensation equivalent to the dower. But courts in Muslim countries have held that where Khula is demanded by the wife, without her fault, that is due to the fault on the part of the husband, it has become inevitable for the wife to move the application or proposal for khula. In that very situation, a wife may be relieved of payment of khula, may not be required to pay the compensation. But where there is no fault on the part of the husband, but wife herself is not willing to continue in the marriage, and without any fault of the husband, she is seeking the khula from the husband, then in that very case, wife shall be required to pay the amount of compensation at least equivalent to the amount of dower which was fixed and paid by the husband. What is the fault of the husband or wife? Wherein the compensation may and may not be. Fault means that uh, some limit has been set by divine law. Say for example, husband is required to treat the wife gently, fulfilling all his marital obligation. If the husband subjects the wife cruelty, she is treated with cruelty and making the wife of life miserable. Wife uh, uh, is subjected all the time cruelty. Then in this situation, wife is left with no option except to seek the divorce. So in this case, wife may not pay the amount of the compensation. Even without compensation, the husband can be required by the court to pronounce the divorce upon his wife and thereby release her. But if the husband is fulfilling all the obligations arising from the union of the marriage and he is not at fault, even then the wife is not cooperating, the husband is not willing to live with him, and all the time is at loggerhead, no cooperation from the side of the wife, and ultimately has moved the application or proposal to release her, then in that very case, wife will have to compensate the husband in lieu of her release from the bond of the marriage. This is a ruling given by the courts in neighboring Muslim countries, which is a good law, and in Indian courts should also take into consideration if such type of the matter comes up for disposal by them. Mubarak is another mutual. I have already said that as the husband can divorce, wife can seek the khula. In the same way, sometime if both the parties are not willing to live with each other, and in the given circumstance, both of them are desiring to dissolve the marriage, then they can dissolve the marriage with their mutual consent, and this way of dissolving the marriage with their mutual decision is known as khula. This right is available. However, by means of the Mubarak, divorce or dissolution of marriage can take place only when both the parties willingly, jointly express their desire or willingness to dissolve the marriage. The process of Mubarak begins when either husband or wife proposes the dissolution of marriage and other party consent to it. Once both the parties agree, and with their agreement or pursuant to the agreement, proposal for divorce is moved before a court of competent jurisdiction or authority. uh, the divorce is finalized without the need for the husband to pronounce the talaq, and the decree of divorce can be passed, and decree of divorce will be as good as the divorce given by the husband. However, if the parties mutually agree and the wife requests the husband and husband pronounces the divorce, then this will also come in the category of uh, this Mubara. Mubara is governed by specific legal requirements to ensure that divorce is valid, divorce by mutual is valid, and for that there must be mutual agreement, no requirement for compensation. Divorce by mutual consent is one irrevocable divorce, and even when there is a dissolution of marriage by Mubarat or a mutual agreement, mutual consent, uh, iddat will still be required, meaning thereby the wife who has been given the divorce pursuant to the mutual consent will have to undergo a period of the iddat, which is required in case of divorce by the husband or talaq by the husband, ensuring no pregnancy and providing a period of reflection. So, divorce by mutual consent under Muslim law is significant in modern legal context because under other legal system, under the Hindu Marriage Act 1955, under the scheme of the Hindu Marriage Act 1955, also there is a provision of section 13 subclass 2 is there, which also affords the uh, uh, ground for divorce. The mutual consent is as a ground for divorce. So, uh, divorce by mutual consent under the scheme of Hindu Marriage Act 1955 was enacted in 1955, whereas divorce by mutual consent under the Muslim law was enunciated much before, that is in the early period of Islam, and legal provision for divorce including the Dissolution by 1939 further enhances this right by providing judicial oversight and protection to the women seeking the divorce. Now, another uh, mode of divorce recognized under Muslim law exclusively available to the Muslim wife is Talaq-e-Tafweed. This type of the provision so far has not been made available under the structure, legal structure, under any legal structure of any civilized system. That is Talaq-e-Tafweed. Under Islamic matrimonial law, a husband can divorce his wife without intervention of the court or Qazi. However, he can either exercise the right of dissolving the marriage himself or can appoint an agent to exercise his power on his behalf, or even sometime under an agreement the husband can delegate the power of pronouncing the divorce, his power, because the power to pronounce the divorce is the exclusive right of the husband, and this right is normally exercised by the husband. But sometime pursuant to an agreement between the husband and wife, this power of pronouncing the divorce can be delegated, can be given by the husband to his wife, and the wife can dissolve the marriage by pronouncing it upon herself in a given circumstance. And this delegation of the power of divorce to the wife by the husband is called Talaq-e-Tafweed and is well recognized under Muslim law, and it is exclusive right of the wife to dissolve the marriage. The meaning of Tafweed is is the entrustment with the wife by the husband of the right to act as her husband's delegate in effecting the divorce to herself. Hence, the wife's making it a condition with the husband at the time of her being contracted into the marriage that she shall have the authority of effecting the divorce to herself is legally valid. Likewise, the delegation of authority by the husband to the wife at any time during the married life effecting the divorce to herself is also valid if the wife at the time of the marriage contract acquires the right from her husband of effecting the divorce, or she becomes entitled to this right after the marriage contract. So, what is Talaq-e-Tafweed? The fundamental rule is that at the time of marriage, parties may enter into an agreement, and stipulate that in certain event, the event may be specified that in the event she will be entitled to divorce, to pronounce the divorce herself upon herself, and if the husband agrees to it, then on the happening of that very event, the wife will be entitled to pronounce and can pronounce the divorce and can repudiate the marriage. She will be at liberty to repudiate the. Say for example, at the time of the marriage, A and W agrees that if husband contract the second marriage, bigamy, wife will be entitled to pronounce the divorce upon herself, and if the husband takes the second wife, first wife will be at liberty to pronounce the divorce upon herself under the authority of delegation. So, if the man says to his wife, choose divorce yourself, the woman has power to divorce herself so long as she remains in the specific situation in which she received it. But if she moves or turns her attention to anything else, the power thus vested in her is done away, and her option no longer remains, because exercise of the optional power thus committed to the women is held by all companions of the Holy Prophet to be restricted to the specific situation in which it is received. All the Sunni schools recognize the doctrine of Talaq-e-Tafweed because this is an important right given to the wife by the Sharia law. According to all the Sunni schools, the doctrine of delegation of power of divorce to a Muslim wife is based on an incident mentioned in the Holy Quran, which is narrated via a verse enshrined in Surah Al-Ahzab. There are judicial decisions supporting to the right of Tafweed. Gul Nawaz Khan versus Musammat Mehrun Nisa, Mirza Ali versus Maimun Nisa Begum. These are the cases wherein the concept of the divorce has been fortified by the judicial authority, even in India, that it has been held that it is a unique, clear, that it is quite clear from the Muslim authorities that a wife can dissolve her marriage regardless of the fact whether condition is in restraint of the marriage or is now considered unreasonable or opposed to the present public policy. Hence, no objection should be raised to the delegation and exercise of such power by the husband. Effect of delegation by the husband. What is the effect of Talaq-e-Tafweed? Power of pronouncing the divorce delegated by the husband to his wife is irrevocable. Means, once in the exercise of the delegated power, wife pronounces the divorce upon herself, then it will amount in one irrevocable divorce, and on the expiry of the period of the iddat, the marriage is finally dissolved, and thereafter if the parties want to reunite with each other, they can of course reunite with each other only by fresh marriage. So, when there is an agreement between the husband and wife that on the existence of certain specified conditions, wife will be entitled to divorce herself or pronounce divorce herself on behalf of the husband, and that event happens. For example, if the agreement is that in case the husband fails to pay the maintenance for a period of 4 months or whatever time may be fixed, and if this event happens, husband has failed to maintain his wife for continuously for a period of 4 months, then on the expiry of 4 months, the wife will be entitled to exercise the Talaq-e-Tafweed and can pronounce the divorce upon herself, and thereby she can repudiate the marriage. After the dissolution of the repudiation of the marriage will stand repudiated. This will amount one divorce, one irrevocable divorce, and the wife will undergo the period of iddat. On the expiry of the period of the iddat, marriage will finally stand dissolved, and thereafter if they want to reunite, they cannot reunite unless there is a fresh union of the marriage between the husband who delegated the power and the wife who exercised the power of the divorce. So, a divorce in the exercise of the Talaq-e-Tafweed basically is equivalent to one divorce pronounced by the husband in the exercise of the formula of Talaq-e-Ahsan, as in case of Talaq-e-Ahsan, on the expiry of 3 months, one irrevocable divorce takes place and marriage stands finally dissolved. In the same way, on the same reasoning, on the pronouncement of divorce by the wife upon herself in the exercise of the delegated power, one divorce will take place, and on the expiry of the iddat period, that is 3 next menstrual period, marriage will stand finally dissolved, irrevocably dissolved, and there will be no scope of again reunion. However, they can reunite by means of the first marriage. Thank you very much.